All right, so we are now into the month of February. I better flick this up so you guys can actually see me. So February 4th, welcome, another hot topic. I'm going to do a little precursor here in the beginning and another one at the end to let you know next week is our deep dive. We are going to have Katie Lance. So I'm going to ask everybody who's on now, spread the word, gather in the office, check with your manager, see whether or not they're going to do it as a lunch and learn, bringing some food in for you. Katie Lance has been named as one of the top 100 most influential people in real estate. And we've got her on next week to share with us. Everybody knows what I speak of as being actively passive. She's going to talk on building a 12-month calendar using actively passive techniques. Putting that calendar together so that you got something to run for the next 12 months. So should be a great program, spread the word. And then the week after, Radon. And I look at faces. Radon. It's something that we have to be aware of. So I took a look back. It's been a few years. Matter of fact, it was in 2022 that we actually did this. So it's coming up on 3 years since we've talked about radon and understanding radon and radon mitigation systems and EPA limits and so on. So I've got Epic Radiation Solutions coming in on the 18th to be able to share with us about that. So there's a couple of things that we've got. Today, it's a did you know? And there's a few things that sometimes it's just we should know, but we don't. And that's where it's going to be beneficial to our business. So let's get into it. See if this will work for me. All right. We're going to talk a little bit about Seller's Disclosure Act. Because when I ask people who needs to disclose, typically we really don't have the direct or immediate answer. So as you can see here, and this is directly from the act itself, and I've highlighted, it is on not less than 1 or more than 4 residential dwelling units. So it has to be a dwelling, so therefore vacant land does not require sellers to disclose. 2, it is on residential dwellings, 1 to 4 family units. If it meets that basic description, then a seller must disclose. So here's the simple parts with the instructions to it. It gives the statement, what the seller's disclosure is. It says they're not an electrician, a plumber, HVAC, or any other things. They only know what they know. But it says this information is a disclosure only. So I always question, have we ever read this? Did you know that this is a disclosure only? It is not intended to be a part of any contract between a buyer and a seller. Now, here's another did you know? Yes, they're required to disclose, but if they don't, what may happen? Well, that's the next part. Failure to provide purchaser with a signed disclosure statement will enable a purchaser to terminate an otherwise binding agreement. So if you ever get one and there isn't there, well, yes, you're supposed to, but if you don't, this is what can be there for the purchaser. And there's one other one that I got on here with this part as a did you know? Because I would hope that you'll never call anybody and say, well, yeah, but it should be included because it was on the seller's disclosure statements. And what I'm talking about is any personal property. I actually had this happen. She wrote an offer. It was on the purchase agreement. Didn't accept. Wrote an offer. Didn't accept. Seller got another offer from her. Didn't accept. Got a 4th offer, and the appliances were no longer on it. My seller said, I can live with that. Those appliances cost us $7,000 5 months ago. So seller accepts the offer. They receive possession of the property. I get a call where there are no appliances. And I'm going, yeah, so? She says, well, they were included. I'm going, no, they were not on the purchase agreement. She says, but they were in the MLS. I said, yes, they were, but we were also asking $10,000 more. You want to pay them $10,000? I'm sure they'd be happy to give you the appliances. And then she goes, but they were even on the seller's disclosure statement. It was great because I knew enough to be able to pull this out and read very specifically. The items below are in working order. The items listed below are included in the sale of the property only if the purchase agreement so provides. So I'll tell you, many of you, and we won't ask anybody to raise their hands, don't know that that little brief statement is actually on there. Important that you know, okay? But let's go on. Have you ever, and I wish I would have actually found one, but here's the question. Have you ever had a seller go, never lived in, or have you ever received from a seller, from a listing when you wrote the offer? Seller never lived in. All of us have had that. All of us have seen that. And gang, what I would tell you, based upon the seller's disclosure requirements, there are exceptions. There are people who are properly exempt from disclosure. Now, I don't know about you. I don't know all of them. But I know where to find out who would be. And I know there's a form that exists to help me out with that. So did you know of this form? No. Dinesh, did you ever see this? Unless we've talked about it, I think you know. No? Anybody out there? I'm going to look at faces that I can see. Give me this. There's no, Tom, thanks. Stephanie did. Good. Yes, Martha, you better. All right. So if this is not in your forms library, and I'm not saying Coldwell Banker Professionals or the Century 21 Professionals forms library, but within any of the libraries that your MLS is a part of, then let me know. Because I think this is an important one that's going to help cover us when somebody says, well, I don't have to fill that out. I've never lived here. That by itself is not an exemption. That I can tell you very clearly. Just because you've never lived there is not an exemption. If you've owned it for 30 years and you've rented it out for 30 years, you know something. Even if, because look, there were repairs on it, right? You know something. Here's the biggest, this is the biggest one, the flipper. Because they've never lived in it. So you're telling me you know nothing about the property? Oh, no. No, so we then need to talk to this seller. In this case, we'll use a flipper, and we would pull out this form. And I go, great. Here's all the individuals that are exempt. Please find the one that applies to you. They're not going to find one. And therefore, what are they going to have to do? They're going to have to fill out the form. And look, if they want to go unknown, but they know. That's the whole point. There are things that they know. They have paid it. If they didn't do the work themselves, they've paid individuals for the work that they've done. So if you ever see a seller, and here's what I would tell you. If it's your seller who says, Well, I've never lived here. You could pull this out, or you say, well, unless if there's something I'm not understanding, you still need to disclose. Now, if they say, well, no, I'm exempt. If they know the word, then we pull out this form. It is in the packages. I can't say because of, I'm going to refer to our new Blue Crew members, that it's going to be in yours. But I do know if you're a member of GMAR, it's in there. Because the one that I'm showing you is a GMAR form. I believe it's Grosse Pointe Board in Livingston County. So if you're Real Comp, you have access to it. If you are GMAR and Flex, you have access to it through GMAR. If you're MI Real Source, it's in their library because GMAR is part of that also. If you're on and it's not part of, if you can't find it, let me know. And then we'll work to be able to get it into your hands so that it's available. Because I think this is a real key in a simple document to make sure that we're getting things done properly, and also informing and increasing the knowledge of all the realtors whom we have to work with. And hopefully we'll see that many fewer I've never lived here. Now, couple of the key ones, bank-owned properties, the first one, including probate court orders, writ of execution, foreclosure, beneficiary of a deed of trust. That's one, that's a common one. Transferees to a mortgagee by a mortgagor or successor in interest who is in default. Otherwise, here, I'll just give you the keys and I'll sign off. This is not anything most of us would have to be worried about, would it? Transfer by sale under power of sale or any foreclosure sale under a decree or foreclosure or transfer. Yeah, no. Right? I mean, it's already going whoosh right over. Transfers by a non-occupant fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. Yes, that is one that we could run into. Okay? But a non-occupant fiduciary. Well, let's keep reading here too. Transfers from one co-tenant to one or more others. So if the three of us in this room bought a house together, but you decide you don't want it, we'll take the two, pay you your share. We don't have to have you do a disclosure because we already know, right? Transfers made to a spouse, parent, grandparent, child, or a grandchild. Otherwise, that familial change, but notice it's only really immediate. Spouse, parent, grandparent, child, or grandchild. Transfers between spouses resulting from a judgment of divorce or separate maintenance. Again, we're not going to be a part of that at that point. We wouldn't be part of the previous one. Transfers, exchanges to or from any governmental entity. Transfers made by a person licensed under Article 4, 299, 1980, newly constructed residential property that has not been inhabited and was built by a licensed Michigan residential builder. Will we run into that? Yes, that is a common exemption. Then the obvious, properties containing more than 4 residential dwelling units. Anybody know why? When it's 5 or more units, what is it? It's going to be an apartment, but what type of real estate would it be? How would it be zoned? Commercial.
Commercial.
5 or more units is going to be treated as a commercial property at that point. Okay, so good stuff. So really, I want to create a scenario then, because this is very common. And I think we at least need to have a discussion. So I've got Cliff here. Cliff's been taking care of his parents for the last 10 years. been taken to the house, and it's now at a point where over the past 10 years, now both his parents have passed away, right? So Cliff is now the personal representative of the estate. My question to you in this scenario, does Cliff know things about the house? Well, let me ask you, anybody who owns a house, have you ever had anything go wrong over the last 10 years? Does Cliff know things? There's things he knows, right? He's been taking care of the property. He may not know everything, but there's a spot on there that says unknown. So here's what I want you to catch, because Cliff just looked at it and went, well, if that's me, I'm a non-occupant fiduciary. He's the trustee for the estate. So now I ask you, does Cliff have to complete the seller's disclosure, or is Cliff exempt? What say you? I
He
have
has
to
to
exempt.
complete.
What's that, Carl?
He has to complete the seller's disclosure.
He has to or does not have to?
Does.
He is actually exempt. So I want you
Even
to
though
picture
he
a different.
knows things about the property?
Yep. Well, here's what it says. Transfers by a non-occupant fiduciary in the course of the administration of a decedent's estate, guardianship, conservatorship, or trust. And what I gave you a scenario is Cliff in that position. Yes, in the scenario I gave you, that is his position.
Okay.
Let me take Cliff out for a moment and go, it's an attorney who's been appointed as trustee of the decedent's estate. Would you expect that attorney to do a disclosure? No, the answer is no. So, in Carl, so I'm glad that you jumped in on this, because you're exactly where I needed somebody to be. In a Con Ed class in Troy 2 years ago, some of you might have been there with me, I posed a question to, everyone knows Jack Waller, and I think everybody knows Rick Linnell. And I posed this scenario to them because, like Carl, what you're thinking, he knows stuff. And yet he's exempt. What is he exempt from? The completion of the seller's disclosure statement. However, he's not exempt from disclosure of material defects. If Cliff knows that it has a cracked heat exchanger on the furnace, that could be a deadly circumstance. Matter of fact, if you were to have the gas company come out and check that furnace and they found that out, off goes your gas, you have no heat, because that's what they're required to do. That is a material defect. So even though he's exempt from the seller's disclosure, would he still have to disclose that material defect? Yes, because he has knowledge of that. So to summarize what Jack and Rick said, it was a split decision. One was saying, well, they should disclose. The other was saying, well, I don't know if I'd ever ask or want or require. I wish I could remember the exact word that was used, but I think it was required. I don't know that I would require someone who is exempt to complete the seller's disclosure form. So my guidance to you is this: hold the discussion. And what are the pros to disclosing and what are the cons to disclosing? because we're only going to disclose, yes, it works. No, it doesn't work. I don't know if it works, or it's not applicable. We would discuss and make sure that they would know, well, based upon this, would you say you're exempt? Yes, I am. Great. So then the only discussion is whether or not you want to disclose because of what you know. Does that make sense to everybody? Let's open it up to questions with this part of it.
Darwin?
Yes, Miss Stephanie.
Okay, so this is what I always say. And that is, regardless of the situation, if they need to disclose or not disclose, although I feel pretty confident everybody I've worked with, although I'm going to be working with some probate cases, but it's always better to disclose everything, because that way it protects you from somebody coming back later on you and suing you, right? Coming after you because you didn't disclose that there was a big fat water leak. And even though you didn't have a requirement, you knew about it. And because you talked to the neighbors and neighbors told the new buyers that those windows always leaked, because I had that happen. I just tell my sellers to disclose everything, even if you think it's going to be bad and negative up front and people won't want to buy your house. Better they know now than later and come after you.
Yeah. I like that because again, you know, you discuss the pros, you discuss the cons, and I'm a big fan of disclose, disclose, disclose.
I have a question.
What is it going to hurt? Because especially if they do an inspection, they're probably going to find it out anyway. So why not let them know up front?
Darwin,
Yeah, go ahead, Deanna.
can you have the transaction without a seller's disclosure? Just omit it altogether? Is that possible?
So the Seller's Disclosure Act requires that a seller do that. But if I go back a couple of slides, remember it provides, again, this part right here, failure to provide a purchaser with a signed disclosure statement will enable a purchaser to terminate an otherwise binding purchase agreement. So I guess to an extent, the answer is no, but yes.
Okay, well, and you know this, but I have a a situation that the seller's daughter is the listing agent. The seller lives in Florida, has not lived in the home for over 10 years. The grandson lives in the home, and the listing agent said, my father cannot fill out the seller's disclosure because he doesn't know what's working and what's not working. So I received a seller's disclosure that everything was unknown, unknown, unknown. And then at the bottom where you have to actually fill things out as far as water damage and stuff, nothing was filled out. So essentially, I don't have one because they weren't going to sign one.
Yeah.
And he's not exempt.
Yeah, you know that
he has no exemption either.
Yeah, so what I would say is outside if he didn't complete it in full, he would, if he truly knew nothing, it was completed correctly.
Right.
So if you ever have anybody that says, well, I haven't lived there. Okay, then here's what you're going to do. You're going to go through each item. Do you know if it works or not? Yes, you do, or no, you don't. And if you don't, what might be your best answer? Unknown. So the reality is if it were true that he literally knew nothing about it, which is a good possibility, I mean, not knowing the circumstances, let's create a pretty clear one. He's been in Florida, lived there for 10 years, and bought a house under his name for his grandchild. He's never even seen it. Is it a good possibility he would have unknown on every item?
That's not the situation. They've owned the house.
Yeah, I understand, but I wanted to bring that clarity.
Okay.
So if they put unknown, but they knew, well, there may be issues that you're going to have to deal with. But most likely, probably not.
But the bottom line, does it have to be signed by the seller and my buyer, even though it's not filled out entirely? Does it still need to be signed and submitted for docs?
Well, Yes,
Okay,
yeah, because you're signing acknowledging what you've got. Yeah. So if, by the way, if it wasn't signed by the seller, then it really wasn't provided. Because again, it says they must provide a signed seller disclosure. So the only real thing would be is if the seller never signed it, well, then that little piece of the buyer could always now go on an otherwise binding purchase agreement.
okay.
Okay, great question. I know, Cliff, you had one.
What they must avoid is the neighbor scenario that someone mentioned.
Oh, yeah, so I'll catch up to make sure that you guys catch it. So, in the aspect of non-disclosure, remember there's neighbors. And so Cliff was just starting with the aspect of, well, then they must avoid the neighbor situation.
It could be extended.
Here, talk loud.
Prior knowledge of a pre-existing condition, I believe would be the legal term for it. Someone can prove that you knew about that crack, whether it's been painted over, no matter if it has ever leaked or ever had some sort of traumatic affair, and you knew about it. If they can prove that you knew about it, there's inherent liability there.
Everybody catch that? No? Okay. So Cliff continued, let's take, the vertical crack. No, I did the right motion. Horizontal crack. I went to a small rural public school. A horizontal crack that they then just built a wall in the basement covering it up. What do we have? A material defect. That is not something that the buyer through inspection could discover without removing a portion of that wall to discover it. That must still be disclosed. So that situation is a great description of a material defect. Very good one.
Unless you bought with the covering on and you didn't know anything behind it, so it's not.
Yeah, if you didn't, so Dinesh took it a little bit further. If it was done and it slipped by and you bought the property and you don't know what's behind that wall because you never went to discover it, well, you don't have knowledge of what exists because it was already covered up. And that does happen. And what do you do if somebody discovers that? Expect them to come back on you. And then you're going to have to defend yourself. So yeah, that is an absolute situation. Wow. And I had a few title company ones here that I'm going to skip by. Maybe we'll hit these on a different one. But do we have any more questions on this subject matter? I got one here.
Just the bank will fall into that.
Bank owned would be exempt
Foreclosure.
because of foreclosure. Yep. They acquired it through the foreclosure. So bank owned, I believe in Michigan Sellers Disclosure Act is exempt, but they're not
Darwin?
exempt from the lead-based paint. And by the way, lead-based paint, who has to disclose? 1 to 4 family residential dwelling. Yeah, there's another question there. Somebody spoke up?
Yeah,
Yep, go ahead,
yeah,
Paul.
Darwin. At what point does an individual become a non-occupant?
Wow, that one's
Because
open
let's
for
say they lived in the
interpretation,
house,
isn't it?
for a bit,
Um,
moved out.
I think, you know what, Paul? Probably back to what Stephanie brought up. Disclose, disclose, disclose. Because the act is not going to specify at what point you became a non-occupant. It just brings up that thing of, well, are you trying not to disclose because you know things? Well, what might be best? disclose. Yeah, good question. And I don't think there's a good answer for it. But I've got Tanisha who just said, I'm gonna find that answer. Okay, cool. So if we can, we'll get it back out there, but at this point, yeah, I wouldn't have an answer for you.
I have a quick question.
Yes,
So it seems like we have two kinds of disclose. One is on the form and the other one is verbal. Because the son who was, go ahead.
no, you're good. Keep going, Lydia.
So it seems like the son who helped the parents with the home, he disclosed, but he did not put it in writing. Is that what you're saying?
Yeah, if there's something that I must disclose, otherwise seller disclosure, or if it's a material defect that I have knowledge of, I must disclose that. And it's always best to do that in writing so that you've got your backside covered.
So the son was not responsible for filling in the disclosure, but he had to disclose the defect.
Yes. Yep.
So he was filling in the disclosure.
Nope, he doesn't. He doesn't need to complete the seller's disclosure, but he must disclose a material defect.
And he's
So
doing
he
it
would
on the
make a simple
disclosure.
statement. What's that?
And he's doing it on the disclosure.
Could,
Okay. Where else would he
But-
do it?
on an addendum on the purchase agreement in the
Okay.
MLS comments. But as a minimum, it would end up on the purchase agreement, but I'd start with it in the MLS comments so that it's known right up front, because I don't want to wait until the purchase agreement and then disclose. But I would have it in writing on the
then-
purchase agreement.
So let's say that you have a home on the market and the home gets an offer, they discover mold in the attic. So we know you have to disclose. So would you disclose that in the MLS in the agent section, or would you disclose it on the disclosure?
Yes and yes. I would
Oh, you do it
probably
on
do it.
both?
Yeah, I'd probably do it on both. In which, and of course, now we've got to get into the marketing. I don't want to disclose that a house has mold. I would rather disclose that it had mold, but it's been remediated.
So then if you
It-
did say that it had it and it has been remediated, would you go back into the seller's disclosure and then add a second footnote that it was remediated? Got it.
Yes. Yep, absolutely. Absolutely. Because once they have knowledge, they need to disclose.
Darwin, it's Ann. Do you want to
Yes.
talk about the agent's responsibility to disclose something that is material in the event that the seller does not?
Hey, go for it. I trust you on this one.
So,
So for those who don't know, Ann Hernandez is a long-term agent and broker and manages our Fenton office. So go ahead, Ann.
yeah, so, I had a situation years ago where somebody had a mold issue, they had it remediated, they didn't want to put it on their seller's disclosure form. And they, of course, shared that with me. So, if it is shared with you and it's material, you have an obligation as an agent to share something that is material. And that's the key. It has to be material, because if we know about it, the seller hasn't disclosed it, and then again, there's a problem later and we knew about it, then we would have some responsibility for making sure that has happened. So if it is a material defect that has been shared with us by the seller, that's why we have to tell our sellers, hey, look, you need to disclose this, put whatever reports you want to have in there, but this is a CYA so that you don't have a problem later.
Yeah, there's an old Latin proverb called anus protectus. Thank you.
Darwin, I'd bet my last dollar that if somebody, to what Ann was saying, if somebody had a problem and if they disclosed to us, we didn't disclose, they didn't disclose, they're coming after both of us.
Yes.
We
Yeah,
are
absolutely.
right in that lawsuit too. It is going to be both of us.
So Ann, what do we do if a seller says, well, I don't care, I don't want it to disclose it, and you can't either?
Well, then I wouldn't be taking the listing.
So I want you to hear that.
Yeah.
We'll say it one more time, Ian.
I wouldn't be taking the listing because again, I can't cover that up and they have to understand that you can't cover that up because if it is material and it's going to cause a problem, then, we have an obligation to disclose that. So you just have to be willing to walk away. I think most of the time though, when you remind people that, hey, look, the seller's disclosure is your best risk mitigation tool, period. And just put everything on there, yeah, and it's better that they know up front and you negotiate for it now than you get the call after closing. Well, gosh, look what I found, and that's never good.
Yeah, absolutely. All right, well, I'm gonna wrap things up here real quick because I thought I had a 15-minute session. But you guys never cease to impress me because I worry whether or not I have quality material, and here's one where look at the discussions that we've had and where it's come. So thank you for being with me. Reminder, next week, again, we've got Katie Lance, one of the top 100 influential people in real estate. Katie's going to be bringing a subject matter of creating a 12-month marketing calendar. So we're really talking about what you've always heard me and the coaches refer to as being actively passive, doing the things necessary to get the business to come to you. And that's what Katie's going to be bringing to us next week. The week after, I've got Epic Radon Solutions, who will be with us the following week. Always a great subject matter, definitely one that you want to know about. So gang, I appreciate you. I'll hang out if anybody else has got any other questions, but I want to
do.
give it an official ending so that you guys can leave if you must. Hang with us if you got additional questions.
I have a question for the group because before everybody goes, has anybody ever heard of excessive acreage?
Oh, I believe I know what you're referring to, and it probably involves a mortgage.
It does. So yeah, I was hoping that there's probably no lenders on our Cheryl. Nobody's on this Zoom, but yeah, I ran into a problem with excessive acreage. So there's no lender out there that will do a regular conventional mortgage for a land rich, home poor type situation is what this is. It's over 100 acres. And there's 3 parcels, but what it's come down to, I have to scratch everything I've done to date with the last month and a half, all my purchase agreements and everything else. Then my buyer has to go to a commercial loan because she's going to be running a business. So that's where we're at now. And then it came down to the seller, which I was just referring to on the seller's disclosure, same seller. The daughter, who's the listing agent, she is super cool and working with us on all this, but she ran into the problem. She even called her own lender people because she thought we were crazy. And she ran into the same thing. Nobody will do it. So she's going to rezone the property.
So let me give you a little bit more to what Deanna is bringing to you here.
Yeah.
The lender wants the value in the property, not in the property, in the home itself.
Correct.
They want around 75% of the value to be backed up, supported by the home and not by the land itself. So when you get excessive land value, they don't want to lend on that portion. They don't want that to be the collateral against the default. So if you ever have that, you're probably going to have to find a creative way to actually buy the home and then the additional land separate from it.
Correct. That's what we're trying to do. She's the seller. We're going to try to rezone. I know it takes a lot of time. I probably won't close until June, but they're going to try to rezone it so the home sits on 2 acre on a 2 acre parcel, and then the rest of the property we're going to land contract out.
So not rezone, Deanna, is it, but more of a survey, just getting the survey.
I'm sorry. Yes, they're going to resurvey. Yeah, so that they can disperse the property more accurately to reflect the home. so that we can get a mortgage on the home and the 2 acres and then do a land contract on the rest of the property is where we're at now. But
Yeah,
I just,
this is great, what I refer to as my This Week in Real Estate. Because
Yeah.
you guys run into these interesting situations. This is a wonderful way for us to all learn. Because it's the way that I first learned about it. And that
and-
was,
right,
wow,
and
long ago.
interesting enough, the listing agent / daughter is like, well, I can't really sell this to anybody. So she has to do this. There's no other way out unless somebody comes up with 1.5 million in cash and just hands it to her, which isn't gonna be the case.
There's lots of people with that.
So
Deanna?
anyway,
Right.
yeah,
Deanna, what is considered excessive? Like it was 80 or it was 100 acres. What if I've got an 85 acre piece of land?
anything over 20 acres, they won't do. So we have
Yeah.
to, they have to survey it and get down the house and put it on 20 acres or less and then land contract the rest of it out.
And the other way that they may do it is a percentage of the value. So if 25% was the number back when, if 25% of the value is in the vacant land, you're fine. If it goes over that, or I'm going to say, just know that it's in that direction, you're probably going to have to separate it out. So if more than 25% of the value is in the land, you're probably going to have to separate it out.
Yeah, and interesting enough, there's an office on the property, there's like a pole barn, there's other structures. And then my buyer is gonna be running a business, so the business also comes into play with getting a loan. If they're gonna have an operating business, some loan people won't loan for that purpose. So.
Well, that's a good one. Thank you for bringing it up, Deanna, because
Yeah.
it's not common, but beware, because if it is excessive value in the land itself, you may end up having a deal fall apart.
Yeah.
If you don't have a seller and a buyer who's willing to get creative. And by the way, with that, legally creative, I should say.
Correct.
Legally
Yeah,
creative.
exactly. And the commercial loan, that could take 6 months, you know?
Yeah.
But anyway, thank you.
Everything changes. Great one. Thanks for bringing that one up. All right. Well, did anybody else have anything else? There's still 30 of us plus on the Zoom call here. Everybody's good?
Hey, I'm talking a lot and I apologize for that. And I have a question that I should know the answer to, and I do not.
Bring it on.
I don't call FSBOs, but if I were to call FSBOs, can I provide them as a courtesy, a copy of the seller's disclosure? Well, and lead-based paint. Am I allowed to give them copies of that to fill out?
I want
whether
to
or
see
not
what your
they use
manager
me?
would say. No. Matter of fact, the answer is yes, you are fine to do that. And I would also say that licensing law would require that you provide that. Because it's not a company form. It is a form that is provided as the act provided it.
So
yes.
And I can provide it as a courtesy, whether or not they list with me, can I just give them okay.
Yes. Yep. Absolutely. Matter of fact, any of the standard forms like that, say add the lead-based paint would be another one that you would provide as a courtesy. But yes, I unless if the law changed, if somebody asked us for one, we are to provide it to them.
Thank you.
Yeah, absolutely. Again, that's just a standard form. So yeah, you would provide it to them. And preferably provide it in such a way that it doesn't have our logo on it at that point for sure. But it's just one of the reasons that particular one we go without it on there. Okay, great question. Good stuff. Anybody else got any? We're kind of on off the time plan and into this week in real estate, but those are a couple of great questions, great situations that we can all learn from on. Everybody's good? All right, gang. Thank you all. Appreciate you. See you next week. 1 hour deep dive. Katie Lance, let everybody know. Have a great week.
Good one. Thank you very much.
Absolutely. I just got to figure out how to get this up to where I can now end it. Everybody hang with me. And boom, that does it.